So joining us right now is Neama Rahmani, a former federal prosecutor, Harvard-educated lawyer who knows his stuff and knows all about this. And he is joining us right now. So Neama, welcome back to TMZ Live.
Harvey, thanks for having me.
So my first thing is this. We did a story this morning on the website based on talking to people who have been involved in these FBI searches that this was not an accident that the raid happened when Trump was in New York and not at Mar-a-Lago, because the protocol is that before they secure the house, they remove the target and will typically handcuff that person. Is that your understanding?
Oh, absolutely. I mean, you don't want the target of your investigation contaminating evidence. You don't want spoliation issues. So you need to remove that person. Look, this is unprecedented. You're raiding the home of a former president. So the last thing you want to do is already throw gasoline on a political powder keg and place them in handcuffs. So this was calculated, and there's a reason that everyone from the top down at the Department of Justice, from Merrick Garland to the agents actually executing the search warrant, did it when they did.
Yeah, and it makes sense. I mean, there were reports that these agents had been in talks with him and his team leading up to this raid, so they kind of waited for him to leave. Can you talk a little bit about what they needed as far as providing evidence to get a judge to sign off on this thing? It's not easy to do.
No, not at all. And this was a referral from the National Archives, who had been communicating with Trump and his representatives about these documents. So we know that there were 15 boxes labeled top secret. Those were returned, but apparently there was a lot of other documents that were shredded, flushed, burned, and that's all in violation of the Presidential Records Act. So the agents, and we don't have it yet, but we will get it, the affidavit of probable cause. There has to be a sworn statement in support of a search warrant. Likely an FBI agent signed that. And a former federal prosecutor like me knows that assistant U.S. attorney or someone from the Department of Justice went to a district judge who signed off on this search warrant. So he or she believed that there's sufficient probable cause that the former president committed a crime here.
So I'm asking you to put on a hat that has both the political side and the legal side. There are multiple investigations going on involving Donald Trump with the January 6th insurrection, with election fraud, and yet the warrant involves material, stuff, documents. I don't want to minimize this because it is a crime, but it feels a little like going after Al Capone for tax fraud. And I'm not trying to paint it necessarily that way, but you know what I'm saying?
Well, the important provision of the act that the former president may have violated, which is 18 U.S.C. 2071, it has a disqualification provision. So subsection B says, if you take or destroy public records, you're charged, you're convicted, you are prohibited from holding public office in the United States. So that's really the potential play here. Now, there's a question of whether that's unconstitutional or not. But if it is, if Trump is charged and if he's convicted, he's going to be barred from running again in 2024.
Well, but then that raises the issue of, you know, that the people who are pro-Trump are going to say this was designed not to prosecute him for the crime, but to make sure he doesn't run for re-election. Of
course, a lot of people are saying that this is a political play. Shortly before the midterms, we know that the Republicans have made strong gains, in large part because of the economy. So obviously the Democrats are going to push Roe v. Wade and Hobbs, but this may be a political play for the Democrats to not only exclude Trump from running in 2024, but to keep the Senate and the House during the midterms this year.
And help me understand, I mean, we just talked about the other investigations, too. If the agents who go in there and seize evidence they think could help them in this case of taking the confidential documents, they find other evidence that may help those other investigations, that's fair game, too, correct?
Absolutely, and they are related. We know the January 6th committee asked the National Archives for Trump's documents related to the Capitol riots. And he sued, went all the way to the Supreme Court, and he lost because Trump wanted to prevent the committee from getting these documents. So absolutely, the investigations are related, and there's no question that if there's materials that Trump has in his possession or materials that he destroyed that basically gives him exposure with respect to more serious charges related to January 6th, that the Department of Justice is going to pursue those charges.
So I was watching one of the news shows last night. I'm afraid to ask you this because if I'm really wrong, I'm going to be embarrassed here. But the person who was on, one of their legal experts, was saying that if in the course of looking for documents, they find incriminating documents involving election fraud or the insurrection that could incriminate Donald Trump, that too would be fair game. I thought because the warrant would be structured in a way that there are particular things they're looking for, that if they go into a safe and even if they find those documents, if it's outside the scope of the warrant, they can't use it. So tell me if I'm right or wrong here.
Well, you're right, and you're right. So the warrant has to be narrowly tailored. It can't be overly broad. That's one of the reasons that the defense can try to quash the warrant or to suppress what was found as a result of executing the search warrant. But as long as the search warrant is narrowly tailored and it's supposed to find evidence of a crime, if law enforcement happens to find additional evidence that supports another crime, that is fair game. And the classic example is cell phones, computers, laptops. When they're seized, agents go through it, and sometimes they find evidence of child pornography. It may have nothing to do with the original search warrant, but that's fair game, Harvey.
Yeah, except
Yeah.
the cell phone is the basis for the search in the case you're mentioning. In this case, they're looking for specific documents that relate to one thing, which is taking material from the White House that he shouldn't take. So it's a little different than a cell phone because the cell phone itself has a lot of information that's all fair game. Here, they've kind of structured it, haven't they?
Well, yeah, but the Presidential Records Act is very broad. It's not up to the former president to decide what material must be maintained, what can be destroyed, what can be shredded. That's up to the National Archives. So if you look at the plain text of the act, Trump and his associates had to maintain everything. So the fact that he's allegedly destroying these documents, flushing them, burning them, that is not a decision that he can make. So to the extent that the archives want everything, Trump needs to maintain it, and he needs to return it if he removed it from the White House.
Interesting. Hey, Neama, really, really appreciate you coming on. That was useful information. Thank you.
Thanks, Neama.
Thanks, Harvey, Brad. Great being on as always.
Thanks again. Okay, we are going to take a break. When we come back,